Wise Counsel Live. We're actually probably going to be updating the name of this to Wise Counsel Weekly. We think this will probably be a thing that we do ongoing coming out of the coronavirus period as we like to do during this time, we like to share the meme of the week. And, we've just made Mother's Day easy for you if Mother's Day didn't already happen, but maybe you'll think about that special someone on their birthday or Christmas. So there you go, in memory of coronavirus. I think Sydney told me these might have actually been a real thing, Brad, that somebody was manufacturing, and maybe they just stumbled into the sweet spot of opportunity here.
Bob, I would love to have a set for my wife. She would really.
Well, maybe they're available through one of the local retailers. I don't know.
Right. Kindred Scott, maybe.
Yeah, maybe so. All right, so it's good to have a chance to talk with you, Brad. I've been looking forward to this, and we're going to talk a little bit today about something right in your wheelhouse. Actually, we're going to leverage off of an article that you recently published in Forbes. I'll pull that up here in a second, but before we get into the article and kind of walk through that, I thought it was kind of a good example that I personally had recently that I would share just to kind of put this into context. For years, I've been talking to people about the importance of having a will, and you can talk to people about the things that could happen and go wrong if you don't, but it's one thing to talk about it theoretically versus going through it yourself. And I actually had the experience of a distant family member passing away. I'd actually never met this person. He was a second cousin, and he had no will. He had no beneficiaries on his IRAs or his, anything that passed by beneficiary. And he was never married, never had any kids. And so, long story short, he was discovered and in his place where he lived. He was in Houston, and the neighbors just were able to dig around and find a connection to a relative. And through a series of phone calls, they kind of started this process that took over a year for the courts to finally make me the court-appointed administrator to be able to officially start doing stuff on behalf of the estate. And that's an extreme example. I know you've shared with me before, these things can often go on 2 years. And I always thought, man, that's a long time. But even in a very simple, straightforward thing like this, the thing that took so long was having to go through without a will and establish who the heirs at law would be. And, that is a huge issue. And one thing that happened that I thought was irritating, but you may have seen this before too. This was totally out of the blue. The estate had paid a genealogist to go back and document all of this. And we thought we pretty much had it down to 3 people. So it was pretty easy in our case. But then out of the blue, another attorney files into our case and says, I think that I've got another heir here. And what was so frustrating about that is that it put all the burden on us to go prove whether they were or were not an heir. We thought we were ready to go to court and we couldn't. So extended it another 3 months before we could finally just take care of basic things, like, paying the mortgage on his place, right, and things like that. So I don't know. I thought since that recently happened to me in the last 18 months or so, 2 years, it took us from start to finish, it took us 1.5 years to get his estate settled. And it was a relatively simple thing. So, that is a very good story, I think, to set up the topic we're going to be talking about today and that you wrote about in your article. I'm going to pull the article up, but while I'm doing that, Brad, why don't you just tell us real quickly a little bit about yourself and kind of what makes your firm unique in the Austin area?
Well, thanks, Bob. No, it's a pleasure to be here, and it's a pleasure to talk to your clients and friends. The Wiewel Law Firm is strictly an estate planning law firm. We don't do divorce. We don't do DWI. We don't even do trial work. We just focus on estate planning and probate. And because of that, we are unique in the marketplace. Lawyers do all kinds of things. Law firms do all kinds of things. We just do this. We have 5, soon to be 6 lawyers. 3 of us are board certified in this. It's a very small number of lawyers board certified in estate planning. One of our lawyers is board certified in elder law, Medicaid planning. So this is all we do. We have an office in Georgetown, Horseshoe Bay, San Antonio, and Austin. And we're seeing people by Zoom now, just like this. We're signing people coming through in their cars. It's really interesting how we get things signed now, but we're very sensitive to what's going on. But on the other hand, we want to make sure we can communicate and educate folks on what they need to know so they can take some action that they know they need to do. They just haven't gotten around to it. And the COVID virus has spurred some people on because we feel a little more vulnerable than we had in the past.
Well, I know one of the things that your firm does that I've not seen really anybody else do is you've got a unique optional feature for clients to kind of have you on retainer, I guess, ongoing,
Right.
and then their documents are automatically updated. Why don't you just speak quickly about that? Because that's a very unique thing you guys do, in my
It
experience.
is a unique thing. Yeah, thanks. It's called life planning, and we have a lot of life planning clients, and not everybody wants to be, but those that qualify for it, yeah, we update something for them every year. We have extensive healthcare instructions, how you want to be cared for if you can't care for yourself, as opposed to just who makes the decisions.
Mm-hmm.
And we review and make sure all their assets are coordinated with the trust. And every 3 years, we replace it with all new stuff. And this year, we're doing things on the Secure Act, which you know about, and making sure that the IRA money that goes to the family goes the most efficient way, and we could hopefully save some taxes on that. So it's a nice thing. We don't charge for phone calls or faxes or emails and copies with that. So we call it a relationship approach as opposed to a more traditional transactional approach where people get it done by the lawyer, and that's fine. They're happy, but never hear from the lawyer again and let their stuff go old. And it does go old, just like we all grow old.
Yeah, I remember one time we were in a meeting with a mutual client, and I don't remember the number. You'll probably remember it, but you quoted kind of on average how many document updates there would be about every 3 years to something like an existing trust or a will. What was the number?
We're going to update probably about 9 to 10 different documents in a 3-year cycle too, because people change their financial helpers. The person I wanted 3 years ago is not the person I really want now, or maybe something's happened to them and they're just the inappropriate person. Maybe they passed away. So we also keep up the financial stuff too, and work with you, Bob, helping you make sure this works on the financial side. That's really, really important to us.
Well, and you also, I think, said in that same discussion that just as attorneys, you're always getting better and always sharpening the saw, and you'll find a little difference of phrase on this feature or that feature, and there's never ending updates on those things too, which is, I think, very true from what we see.
It is true. And again, I used to say the law changes about every 15 minutes, but with the stuff that Congress has been churning out, the CARE Act, the PPP stuff, all that stuff, the law's changing about every 5 minutes. So, life is not a snapshot, it's a video. And so we need to keep this stuff up to date. Yep.
Well, that's great. Well, thanks. I'm going to go ahead and share here as we get started this article, just so people will kind of have a visual on it if they want to go out and read more on this after our discussion today. I believe this was it, right? The Dangers of Dying Without a Will.
Correct.
By Brad Wiewel. And then this was published through, I guess, Forbes Online. And
yes,
you go through and lay out what we're going to be talking about. We actually kind of broke down some talking points today that were pretty much taken from this article. But for any of you who want to go out and read this for yourself, just search for Forbes and Brad Wiewel. And spell your last name for them, Brad?
Of course, it's W-I-E-W-E-L. W-I-E-W-E-L. And our website, Bob, is texastrustlaw.com.
Okay.
texastrustlaw.com.
Okay, great. Well, so let's dig in a little bit here, Brad, and let's talk about this. I shared a little bit about my personal experience, but why don't you just start with the basics, and I'm going to let you kind of walk us through these talking points we laid out, but I guess it doesn't get any more basic than the question of what can happen if you die without a will.
Oh, dying without a will is very, very frustrating. And what's frustrating about it is it's not that everybody hasn't had the opportunity to do it. It's the effect on the family after somebody dies without a will, because just like your situation, the unexpected happens. What you experienced, Bob, is you're now dealing with, and just finished up dealing with, the state mandated will. So what happens out there is that if you don't have a will written by you, you have a will written by the state legislature, because there's a default will out there that will disperse your property to people that you probably never wanted to get it, just like your second cousin. You didn't know who this guy was. Heck, you didn't know who you were, but you ended up with a large portion of his estate that he worked for all his life, that he saved for after he paid all the taxes. And if he'd done a will, he might have wanted to give it to somebody else, but he didn't do a will, and you're fortunate to be an heir. But
Yeah.
who wants to work all their life, pay all the taxes, save the money, and let it just kind of go into the air? So if you
Yeah.
have a will, you decide, you have control. One thing we say, Bob, and everybody's heard this phrase before, in real estate, the three most important things are location, location, location. But in estate planning, the three most important things are control, control, control. So if you, ladies and gentlemen out there watching this broadcast, want to control your property, your assets when you die, you can, and you have to have a will, maybe some other things to go with a will, but at least a will to do that. And it's not very complex, and it's typically not very expensive, but you've got to do it. And when you do it, you'll be happy that you've done it, and frankly, your family will thank you later that you had the foresight to do that.
Well, so Brad, in the case I shared, there were no there were no marriages ever, and
Right.
there were no children.
Right.
But as you kind of walk through some of the scenarios that people might find themselves in, that's what you do basically in the article.
Right.
Walk through a couple of those types of situations and what happens, intestate, the state's will versus, having it in place.
Regarding your own will, right? So you got the state's will, which is the bad one, and the state's will says. So let me go over what I just had this morning. All right. So I met with a couple this morning on Zoom, just like this, and he has a child from a previous marriage. Now, this couple that I visited with today have been married 35 years, but he had a child by a previous marriage. If he dies without a will, his entire half of the estate will go to his children, not to his wife. Okay. And they don't have children, so that child would inherit half of the estate. And I asked him, when was the last time you saw that child? He said, I haven't seen him, heard from him since way before he was 18. I paid my child support till he was 18, and that was that. So who knows what this person's like? But he'll inherit half the house. He'll inherit half the cars. He'll inherit half the money at the bank or the financial institution. He'll inherit half of the clothing and half of her clothing because they bought it during the marriage. All that's community property, and it is a disaster that could be avoided. And he's taken the step, along with his wife, to do a will so that doesn't happen. And anybody who has a child from a previous relationship that doesn't have a will is totally playing with fire, and this is like nuclear weapon fire.
Yeah, we see today, I don't know, more than half of the folks we work with, it seems like have something, life is that's real life today,
it's
right?
Complex, that's right, sure it is.
So whether it's prior marriages or children from prior marriages and all those kinds of things. And, I think it's hard for people to think about that stuff and make decisions, right? And so
Right.
we tend to kind of put those things off. And when we talk with clients, we try to get them to understand one of the values of working with a team like us or somebody else like us is we're gonna try to be politely persistent in bringing accountability to your life in these important areas. And you don't want to badger people, but I mean, these are hard things, but they need to be proactively addressed. I love your comment about control. I was laughing because I do some teaching amongst a group of guys every week, and one of our jokes is, raise your hand if you're a control freak. We all are, right? We all want to have control.
Right.
But when it comes to this is hard to think about, and people just kind of procrastinate. But not making a decision, as we've all heard, is making a decision by default. Right?
That's right. That's right.
These things are just so important. Carry on.
And there's some stuff we need beyond a will, Bob. And let me just chat about this here a little bit too, and then we'll see where else we want to go with it. But everybody, in addition to a will, needs a financial power of attorney. And a financial power of attorney, and you deal with them all the time, is a legal permission slip that says if I can't sign my name, you can sign it for me. And everybody needs one of those. You don't need it maybe now because you have your wits about you. But if you drift into dementia if you get Alzheimer's, if you just get really sick or hurt and you can't make a decision, somebody will need that to be able to give you legal authority, Bob, to let them access the money that they've got on deposit with you, so they can actually use the money to pay the bills and to take care of me. Right? It's the me part that people miss sometimes. They think, well, I'll do the will and take care of them, but they forget about me. A financial power of attorney is very much a me thing. If I can't make a decision for myself, I need somebody who I trust to be able to write a check, contact you, Bob, have you open the account and get money out to take care of me. That's a really key thing. And you've seen that before too. And then beyond that, we need the medical documents. We have to have a medical power of attorney. Hospitals are very, very sensitive now to who's making the decisions. The last thing they want to do is get sued.
Yeah.
With a medical power of attorney, then somebody can make a medical decision for you and have some backups in case something happens to that primary person. Then you need a living will. There's been several articles about living wills, and living wills are pulling the plug. And we've been, interestingly enough, Bob, contacted by a number of healthcare professionals, doctors, nurses, during this crisis, who are coming in to see us to get this stuff because they know how vulnerable they are in the crisis too. So we're doing some planning for them. This living will let somebody pull the plug when you say, I want to pull. Not, they don't decide, you decide. And the other thing that helps with are fights, because kids can fight over whether to pull the plug of mom or dad, and nobody wants a fight. And if mom or dad say, hey, if this lines up, I'm ready to go, I want to go, frankly, please let me go. And then the other thing that you've dealt with plenty in your career, Bob, and some of the viewers here have heard about it, maybe a few have encountered, and it's not always a good thing to encounter, is HIPAA. And you know, and I know that HIPAA is a health privacy law that says nobody gets to know your medical condition unless you give them permission. But if you're unconscious, you can't give anybody permission.
Yeah. So
everybody needs something called a HIPAA release, and you list everybody you want the doctors to talk to, and the doctors can talk to everybody on the list. And that's just a new thing. And people who haven't updated their estate plan in a number of years won't have a HIPAA release. And it's really an important thing. And then the other thing we would say, and I'll maybe wrap up a little bit more on this now, but the other thing that we think is a critical document is called an agent for remains. And Bob, you know what that is. That's where I tell my family, when I do pass away, I want to be buried. I want to be cremated. So your loved ones know that too. And we had lunch with Cookwall and Funeral Home. They're just down Williams Drive from your office. And we had lunch with them one day and said, we use this document. And they just about kissed our feet because they said, you can't imagine the fights that break out at our funeral home over whether to bury or cremate mom or dad. And so this is another document that everybody needs. And it just lets the family know. I decided, okay, may not like it, but there it is. And so they can honor your wishes even in that regard too. So a good estate plan keeps family fights down, which minimize costs, which minimize complexity, of course, at the absolute worst time in somebody's life too.
Well, I just fundamentally look at it as a stewardship issue, Brad. I mean,
Sure.
we want to have our life in order and not put unnecessary burdens on people we care about, and direct our assets and our affairs in an orderly, well thought out manner. And so it's just a basic part of that. One of the things I was going to get you to talk about a little bit is clarify for me exactly what it requires in Texas for it to be viewed as a legitimate will. Because I've heard things over the years back and forth. I've heard every page has to be initialed. I think it has to be notarized and 2 witnesses, those kinds of things. But then you get into this whole thing of holographic wills, handwritten wills. When are they honored? When are they not? I think I heard one time, I don't know if this is true, but I heard one time if somebody wrote it out on like some holiday, they wrote their scratched out will on a Holiday Inn, piece of, or whatever business piece of that would
Just a
somehow
napkin, a cocktail napkin, whatever, right?
Yeah, whatever. I mean, what is the truth on all of that? When is it considered valid? What's absolutely required?
Well, let's talk about that because that's a great question. We'll talk about software wills too while we're talking about all this too, LegalZoom and things like that. So non-handwritten wills have to be witnessed. Handwritten wills are valid in Texas. They're not valid in all states. In fact, I got something from a smart lawyer today, kind of talking about how we're signing things during the virus. And he said a lot of states don't honor holographic wills. And if somebody dies in one of those states, that will be a problem. Okay. But a handwritten will in Texas, if it's 100% in your handwriting, technically would be a valid will. But here's what happens with those, Bob. People don't do them correctly. And you wouldn't do it correctly because you don't know what a will really looks like. If I die, I'll leave this to, well, we're all going to die. But if you say, if I die, that may invalidate the will because it doesn't, you're not saying when I die. This is a testamentary thing. So even a little word like if could screw the whole thing up. And people don't use the magic words. And this is a criticism also of LegalZoom and software wills or online wills, because Texas is Texas, and we have very strict legal words that we really like in Texas. And if some of your clients, I'm sure they have moved from another state, they realize Texas is different from every place else. And we have our own legal words. And if the handwritten will doesn't have the magic Texas legal words, which it wouldn't because people don't know what they are, or the software program or LegalZoom doesn't have the right words, it may skate by as a valid will, maybe, but maybe not. But it will really increase the expense to the family because it doesn't have the words, and the court has to rule on certain things. It just makes a mess of it. So a handwritten will technically is valid, but we see handwritten wills, and honestly, the cost of the probate goes up dramatically because it's always going to have a problem, just like a software will or a LegalZoom will have a problem. So if you go to a lawyer, there's a lot of good ones out there to choose from. We're good, but there's some others, of course. A lawyer will have it done correctly. He'll have all the magic words in there. He or she will make sure it's executed correctly. So it's not just making sure the magic word's there. If it's not 100% in your handwriting, it has to be executed correctly. 2 witnesses. The notary is, interestingly enough, is kind of an optional thing, but the notary helps because you have to go back and find the witnesses when you die, and they testify in front of the court that, oh yeah, Bob was of sound mind, Bob was over 18, Bob knew what he was doing. If you don't have this special little thing called a self-proving affidavit, you got to find the witnesses and bring them to court. Well, 20 years from now, where are those witnesses? Who were those witnesses? So it's do it right, invest the money. And this really, if I can say one more thing, because people tend to see this as an expense, this is really an investment. And back to your second cousin, you have paid in legal fees and your time and everybody else's time, thousands and thousands and thousands of dollars just to get to this point. But if the guy had done a will, straightforward will with all that, he wouldn't have spent nearly that amount of money. So it really is an investment.
No, you're right. I mean, it was a very simple estate on its surface, but you're right. It cost probably 20 times what it would have cost just in legal fees to get to the point where we could settle a simple estate if he had just had a will.
That's right.
Is it required to have each page initialed, or is that just preferential?
It's just preferential. We don't do that here. I think the thought with that is, well, I want to make sure it's obvious that I initial each page, that I mean each page. It's nothing wrong with that, but it's not required. It's time consuming. And frankly, the way that we do our wills, we always have a scanned copy of the entire will. So it's clear this is the will that was signed that day. I think in the old days, when you couldn't have copies and you wanted to make sure that this is every page is here, that's why you would initial it, but it's not necessarily, and it certainly prolongs things. And we have quite a few clients, as you might too, Bob, who have mobility issues, have handwriting issues. They don't, their own signature is a hard thing. And there's a way maybe around that, but to initial 20 pages, 30 pages, 50 pages, it's not necessary, and so we don't do it.
Hey, let me ask you one more thing before we wrap up, because we want we like to keep these discussions, again, thanks for your time, just low, casual and into 30 minutes.
Sure.
But one thing that we run across a lot in our area here, up here in Williamson County, and I know it's true in Austin, so many people are relocating, to the state of Texas, and particularly the Central Texas area. And let's say that somebody, a typical thing we'll see is, let's say they get their will done, but then they've got this property that's not in Texas. Let's say it's a family lake home or something like that in New Mexico or in Michigan or wherever.
Yep.
Now, am I right? What I believe is the case that if they don't do some planning around that, there's going to be probate in both states required, right?
That's right. You can have when you have real estate in more than one state, you have to have a probate in each state. And the married couple that has the home in Colorado, Texans love Colorado, will go through 4 probates. First death probate in Texas, first death probate in Colorado, second death probate in Texas, second death probate in Colorado. So one of the reasons why people use revocable living trust now more than they would a will, which is kind of a will substitute, is if the trust is done right, there is not a probate anywhere. And you hit on a really good point, Bob. People don't know this. They think, well, I got a will, that should work. And it does work to a point, but it really, again, you need to see a qualified lawyer. I'll just write that back up.
Yeah.
Whether it's a Wiewel law firm or somebody else, but see a qualified lawyer that can help you work through this. Again, LegalZoom's not getting you help. Handwriting a will won't give you any help. That's a really good point that you raised, Bob.
Well, it's just so common now. I mean, people are very mobile in our country and our culture today, and particularly in our area, right? All these folks are relocating here, and it's very common for them to still have a place out in California or Colorado or one of these other states. And, they you don't want to just be oblivious to this and create a mess and an expense that was not necessary with a little bit of planning. So, Brad, as we wrap it up, we're all kind of still in this weird time, right? With somewhat business as usual, but business has also been completely transformed in some ways. But yet we've seen a lot more interest from our clients when we're constantly in contact with them about estate planning things. How does somebody work with you effectively right now in this environment? Both from, I guess we can do Zoom sessions, right, and talk through things, but then you still got to execute the documents. Kind of wrap it up by telling us, if somebody really wants to get some help today, whether they've ever worked with you or they're just updating, what would that look like?
Sure. So we don't charge for the initial consultation, Bob, whether that's a Zoom meeting. Starting June 1st, we're going to have, if people want to come in to see us at our office locations, we're open to doing that too. So we would sit down with them and, again, Zoom them, whatever, and just listen to what they need done, and then help them plan for what they need done. Our website is texastrustlaw.com. They can email us. They can call us at 512-480-8828, and we'll work with them and work with you to make sure this estate plan fits together the way it needs to, and I know it needs to, and they would want to have happen.
Yeah. Well, thank you very much for that, Brad, and we're going to wrap up by just reminding everybody on here, if you have questions, unfortunately, we can't take live questions due to legal compliance issues, but we can certainly take your emails, and we will be happy to forward them to Brad and his team. If you have a specific question about anything we talked about today, or if you want to talk to him, we'll do whatever we can to help make that connection. Next week, we're going to be digging in, Brad, to a really simple, but it's amazing how helpful it is when people have it explained, the topic of just the basics of our tax tables, and the idea of, marginal tax rates versus effective tax rates, and why that matters when you're thinking about doing things like a Roth conversion, for example, things like that. So we'll be digging into tax topics next week, but we will definitely look forward maybe to having you on again in the future. You got a little bit into the power of attorney today, and I'd even already thought that would be a great topic for a whole discussion, but you hit on that pretty good today. So thank you for that. Sure. Maybe we'll dig into trust one time. I mean, there's so many things we could talk about, right?
There's a lot of things to talk about, Bob. So you just let me know, and I'll be happy to, again, I enjoy work with you, and I'm sure I'd enjoy working with your folks here too.
Absolutely, Brad. Well, thanks. We're going to go ahead and wrap it up, guys. Y'all have a safe and blessed week. And Brad, we will talk to you soon. Bye-bye.
Okay. Thanks, Bob. Thanks. Bye-bye.